So, it is a great pleasure for me, on behalf of the law faculty at the University of Oslo and the PluriCourts Center for the Legitimacy of International Courts and Tribunals, to welcome Professor Helen Keller, who is a judge at the European Court of Human Rights. Helen Keller is also a long-time friend of the law faculty. She has been visiting the law faculty for several times. She and her family also spent some months in Oslo, living in Oslo, when we were cooperating at the Center for Advanced Study in 2010. So, Helen, you are part of the family. You have a diverse professional background. Your doctorate was in environmental law. You have studied at the College of Europe in Bruges, Belgium, and you have been a research fellow at Harvard and the European University Institute in Florence. You were a legal counsel in a law firm in Switzerland, and you have 10 years career as a professor of international, constitutional and European law, first at the University of Lucerne and from 2004 at the University of Zurich. You were elected member of the United Nations Human Rights Committee in 2008 until you became a judge of the European Court of Human Rights in October 2011. I would like to start our conversation with your practice as a professor and a public discussant and practitioner. You have an extensive academic list of publications, and my first question to you: what are your main areas of academic interest, and why?
Thank you, Geir, for the invitation and for this first question. Since the research on my Habilitationsschrift, which concerned the reception of international law by the US Supreme Court, by the Luxembourg Court and the Swiss Federal Supreme Court, I was very much interested, and I think I am still interested in the interplay of international law and national law. I think courts play an eminent role in this interface between those two areas of law. And I have now the privilege to be a member of the European Court, which exactly plays very often with this interaction between the national law and the European Convention on Human Rights. And I feel so privileged that I can see now from inside how the court acts, and of course I can also influence how the court acts.
Yeah, I think that will be a main focus also of our conversation, the relationship between the international and the national level and the role of courts. But this diverse background, both as an academic and as a practitioner, and I think also from time as an activist, could I ask you what should be the role of a professor in trying to combine these different roles?
I think a good professor should have a lot of enthusiasm to his or her field, and to transmit this enthusiasm to the students. And in particular, in the field of law, I think it is important that law professors analyze critically the jurisprudence of the courts, in particular, of course, of the European Court of Human Rights. They should start with the simple question: why did the court decide like it did? What might be important aspects, convincing arguments before the court that finally made the results? Because we have to be aware that in difficult cases, the decision-making process is long, and very often it is at the beginning a completely open question how the court at the end will decide. So a law professor should teach the students how to convince, because wherever the students will end up as lawyer before a court, as judges in a particular bench, or even as a professor in the academic world, you always have to convince the others with your legal arguments. And that's so important that the professors teach that and the students learn that.
Yeah. Another thing that is often discussed at perhaps particularly at law faculties is representation of both sexes among the professors, but also the role of feminist approaches to law. Has that been of importance in your work?
I have not concerned myself with feminist theories, but I have to admit, the longer I'm in the academic world and the longer I'm a judge at the European Court of Human Rights, the more I'm convinced that it is important to have female professors and female judges. My experience is that female professors have different questions. They address certain issues differently. And at the court, I'm sure that the female judges react on certain issues differently. For example, domestic violence, the sensibility, the understanding is completely different between female and male judges. Or child abduction cases. There, I think there is really a difference between the genders.
Very interesting. So both as a professor and as a judge, it may make a difference. What we will do now is to focus on the European Court of Human Rights. We will address certain judgments, 4 judgments in different areas of law, where Helen Keller has either dissented in her opinion or made a separate concurring opinion. The reason for doing it that way is not necessarily to discuss the dissent, but because these cases bring out more clearly the voice of Helen Keller. And we are aware that you are still an acting judge, so we know that you have to take account of that when you are expressing your views both about current cases and earlier cases. The 4 areas is first, we can discuss whether that is really the right approach, but the retroactivity of, or the possible retroactivity of the convention to earlier cases before a state has ratified the convention. The second area is the relationship between on the one hand, that the court shall ensure an effective protection of human rights, and on the other hand, the balancing of taking into account national freedom, national democratic freedom. So how should this balancing take place? The third area is counterterrorism and the relationship between counterterrorism and human rights. And finally, we will ask about the role and the possible role of the court in interstate conflicts, like we have seen Russia-Georgia, possibly Russia-Ukraine. But we will see what time allows. But the court has existed now for many years and decades, and I find that we should first, I would like first to ask you what has been the main achievements of the court during these years? It's a big question.
I would put it this way. In the last roughly 50 years, the court has contributed to what Alex Stone-Sweet and I called a Europe of rights. To work and argue convincingly in front of the case. So all that contributes to a Europe of rights. But the task of the court is to over and over to hammer it into the heads of the governments and the courts. We have to protect a minimal level of human rights. And not only human rights, there is considerable case law on the rule of law and on democracy. And I think these all together make Europe a region where we had little war. We had some war, but little war compared to other regions in the world.
So the court has made a real difference in the relationship between the international and national law, and not only rights, but also democracy, rule of law more generally.
Yes, I think so.
Yeah. The cases that we will go through, they are all Grand Chamber cases, so they are the most important cases of the court. And they have been decided in the last couple of years, so they are very relevant to the issues that we discuss today. But before we enter into these cases, and I mentioned this role of dissenting opinions and concurring opinions, what do you think is the role of these dissenting and concurring opinions?
Let me start by saying I'm coming from a country where there are no separate opinions in most of the court decisions. And this is, of course, if you have no separate opinions, a way to enhance the credibility, the legitimacy of a judgment. The court speaks with one voice. If a judicial system allows separate opinions, judgments become weaker on the one hand, but also more transparent. I think by reading the separate opinions, you might better understand the main judgment and even have some insight in the decision-making process, which of course you don't have if you have a narrow majority and you don't allow separate opinions. Now, how you deal with separate opinions at the European Court of Human Rights, this depends very much on the professional background of each individual judge, and of course also on the character. Some of my colleagues say, well, I'm not familiar with separate opinion, therefore, whenever possible, I vote with the majority, and they hardly ever write a separate opinion. It's just not in their legal culture. They were not educated to show their disagreement. Other colleagues, they admire separate opinions.
Common law lawyers.
Yes. Yeah. And they write long, elaborated dissenting and concurring opinions. And you see, it depends very much from your background, but also from your personality, how you use those separate opinions. So my personal position is somehow in between. In the decision-making process, I always first try to convince my colleagues. So if I get a draft and I disagree, I either call the rapporteur or write him an email saying, listen, this and this and this are my arguments. I cannot agree. Hoping that I will find some other judges who would follow, and then we will turn the decision. If I end up in the minority, then I write. I hardly used concurring opinions. I did in about 3 cases. And I did some dissenting opinions in chamber judgment and some in grand chamber. And the function is completely different. Concurring opinion, you write really when you say, okay, the result the court has reached is fine. But with the reasoning you have some problems. So once again, in the decision-making process, I try to bring into also my legal reasoning and try to improve the language of the judgment of the majority. If I fail, then I write. A concurring might be necessary because you know it's a concurring opinion on a chamber judgment, but there is a pending grand chamber judgment, and you don't want that the grand chamber will do the same mistake as the chamber judgment do. So this might be a reason why you write a concurring on the chamber judgment. In grand chamber, I recently wrote one in Svinarenko versus Russia. It's a very simple case, a case concerning metal cages in courtrooms. You probably all have seen them on the TV. Khodorkovsky was in a metal cage. Pussy Riot was in a metal cage. And there we had different case law, if this is possible or not. And the Grand Chamber in Svinarenko held, no, this is per se incompatible with Article 3. It's inhuman and degrading treatment. Now, as law professors and law students, you know Article 3 is an absolute prohibition. And you don't have a kind of a balancing right there. But the court's judgment in Svinarenko included some of this argumentation. And then I thought, no, I write a concurring. From a doctrinal point of view, you should just leave out all these balancing aspects. Now, if we come to the dissent, if I write a dissent in a chamber judgment, this dissent very often will contain arguments for bringing the case to the Grand Chamber. So it is addressed very much to the party who has lost the case. It contains argument why this case should go to the Grand Chamber, not necessarily that the case was decided wrongly. I mean, this can happen, but you have to put arguments in front of the panel who will decide on the referral that the case might go to the Grand Chamber, and in front of the Grand Chamber that they might turn around on legal arguments a case. Now, a dissenting opinion in a Grand Chamber case, once again, is a difficult story. There you end up in a minority and it is final. There you write your dissenting opinion for the outside world and ultimately also to the court, because you're hoping that in 10, 15, 20 years, the court will change its case law. So it is rather to the outside world. It is also addressed, I think, to the academic world. But we have to be aware a dissenting opinion is not an article published in a journal. We don't have the time for that. Usually we have, for a dissenting opinion in a grand chamber case, we have 3 weeks. But in these 3 weeks, you have all your single judge, which is in my case some 100, 120 per week. You have ongoing chamber. Every Tuesday you have between 6 and 12 cases to decide, and you might have there another dissenting opinion. You might sit in another grand chamber. So the 3 weeks is really a very limited time, and you have not time to elaborate a really academic article. And we have no help apart from the language check. We write our dissenting opinions ourselves. So they should be short, succinct, and really to the point.
And we are very grateful that you will spend an extra day in Oslo, considering your busy life as a judge. What about the role of what can be called or has been called constructive ambiguity to make a majority? Are there times that you need to compromise in the preciseness of the judgment in order to reach a majority, or do you rather prefer to write a concurrent opinion?
I rather would do a compromise. As I have mentioned, in the 3 years I'm now at the court, I wrote 3 concurring opinions and about 20 dissents. So I only write concurring if I really think it is needed. Apart from that, I allocate my resources to the improvement of the majority judgments and to dissents if I really disagree completely.
Okay. Let's then start on the different cases. The first is Janoviec and others versus Russia. There's a case from 2013, and it concerns the massacre of Polish officers in 1940 in the Katyn forest. Several thousand Polish officers were killed by Soviet forces. Russia acknowledged the massacre in 1990. There were also steps to have criminal investigations, and President Yeltsin in Poland in 1993 paid tribute to the victims in front of the Katyn cross in Warsaw. And in 2010, the Russian Duma adopted a statement on the Katyn tragedy and its victims. The court examined whether Article 2 on the right to life, 3 on torture, inhuman and degrading treatment, 38 on cooperation with the court, and 41 on remedies, whether those articles had been violated. The court concluded, however, that it did not have the competence to examine the complaint under Article 2 on the right to life, and that there had been no violation of Article 3 on torture, inhuman and degrading treatment. But it concluded that Russia had failed to comply with its obligations under Article 38 on cooperation. On retroactivity, the court stated in this case, quote, "The court reiterates that the provisions of the convention do not bind a contracting party in relation to any act or fact which took place, or any situation which ceased to exist before the entry into force of the convention with respect to that party. So that is the non-retroactivity. In this case, Helen Keller and the 3 other judges issued a partly dissenting opinion. They stated, "We agree with the majority's finding that Article 38 has not been violated. To our great regret, we are unable to follow the majority's opinion concerning the findings under Articles 2 and 3. So my question to you, also on basis of what you have said concerning dissenting opinions, why did you dissent in this case, and was it particularly related to the retroactivity of the, or the non-retroactivity of the convention?
Allow me just first to say, it is of course odd to speak about a case in which you sat on the bench. So the majority has spoken and the minority in its dissent. And of course, I'm bound by an institutional loyalty, so even if I disagree with my colleagues in a majority, I'm not in a position to criticize the majority. So let me try to speak in more general terms. You introduced the case as a case which raises an issue on retroactivity. I would fundamentally, respectfully, but fundamentally disagree. Of course, you can look at Janowiec from that point of view. 1940, the convention did not exist at that time, so just forget it. Ratione temporis, we cannot deal with that. Now I have a different perspective on the case. Let us remember that many states in this world have experienced horrible atrocities in the last, let's say, 100 years. And we all agree we cannot undo these atrocities. The only thing that we can help is that societies, modern societies, come to terms with the past. And I think this coming to terms with the past is a very, very essential feature of every modern society in order to live in peace. Think of South Africa, so important. Rwanda, so important that the society comes to terms with the past. Now, if we put that into a more legal language, the procedural obligation in Article 2 and 3 of the Convention, right to life, prohibition of torture and inhuman and degrading treatment, in my view, have an independent meaning. So I don't see Janowiec as an event in 1940 which has no continuous effect. I see the effect on the victims, the children, the grandchildren of these Polish soldiers who were killed in 1940. I see the effect in the 90s, in 2000, in 2004, when the Duma was dealing it, when the Russian courts first decided we can open the dossiers, and then at a certain point said, no, they are confidential, where I see no rehabilitation of the victims, and I see the effect on the children and the grandchildren. And here I think the procedural obligations under Article 2 and 3, they have an independent meaning. It was not a question to find the perpetrators of 1940. The case deals with the question, how do the Russians treat the victims in the 90s, in 2000, in 2010? This was the issue. And therefore, I'm convinced it was not a case on retroactivity. And of course, I had other legal arguments, such as it was a war crime. No possibility of forgetting it. You have to bring to justice the perpetrator. No prescription at all. So, you see, in my view, to say 1940 closed, we have to declare it inadmissible, is much too easy. It doesn't take into account the modern and essential function of coming to terms with the past, which is so essential in human rights terms.
If we continue on that, on the role of the court in relation to post-conflict situation and coming to terms with the past, it has been discussed much about the role of international courts and what they should do, whether there is a conflict or a tension between ensuring justice on the one hand and protecting peace on the other hand, whether it's a conflict between the two. How do you see the role of human rights courts, which is of a different kind than international criminal courts?
I think our court is somehow in between. Janowitz is a good example. As I mentioned before, it was not a question to find the perpetrators. They mostly were death. But it is, I think, our task, the European Court's task, is to transmit a culture of how to deal with such horrible atrocities. And let me add an additional element here. I think it is essential that each generation can write its own history. So if you go back and try to find the truth, it is for each generation to refine the truth. And this is so essential for the freedom of research, but ultimately also for the freedom of speech, that you can put different questions with a distance of 40 years or 60 years to certain historical events. And there is more and more support for a right to the truth in academic literature, but also in some fora, like the Inter-American Court of Human Rights has established such a right. The several bodies of the UN say there is a right to the truth. If I say right to the truth, let me say what I don't mean by that. Under the Convention, under the procedural obligation of Article 2 and 3, there is probably a right to the truth, but not in the sense of a collective right. In the convention system, although the court never explicitly has acknowledged a right to the truth, those procedural obligations come very close to that, but it is always an individual right. And the second clarification to the right to the truth would be, in a postmodern world, in a deconstructed world, we know that there is no such thing as the truth. So, once again, it is always relative truth, and probably each generation will redefine this truth. But it is important that this process can happen.
We will come back to the right to the truth, or a possible right to the truth later in connection with another case, if we have the time. But now we turn to another case, which is Hemmerlein versus Finland from this year. It's of a completely different kind. It concerns a person who changed her gender. She or he was married and wanted to continue to be married. But under Finnish legislation, it is not possible with same-sex marriage. It is possible with a registered partnership. So the Finnish authorities said that you must make a choice. Either you are unmarried or you must transform this relationship to registered partnerships. But both parties to the marriage wanted to continue the marriage. So that was the dilemma. And here we come to the question of margin of appreciation, evolutive interpretation, possible emerging consensus among European states concerning legislation, and so on. The court said that in implementing their positive obligation, they saw this as a possible and not a negative obligation upon the Finnish authorities under Article 8, the right to privacy. The states enjoy a certain margin of appreciation. A number of factors must be taken into account when determining the breadth of that margin, where a particularly important facet of an individual's existence or identity is at stake. The margin allowed to the state will be restricted. Where, however, there is no consensus within the member states of the Council of Europe, either as to the relative importance of the interest at stake or as to the best means of protecting it, particularly where the case raises sensitive moral or ethical issues, the margin will be wider. There will also usually be a wide margin if the state is required to strike a balance between competing private and collective, private and public interest or convention rights. The court further held, in the absence of a European consensus, here we have this European consensus, and taking into account that the case at stake undoubtedly raises sensitive moral or ethical issues, the court considers that the margin of appreciation to be afforded to the respondent state must still be a wide one. In conclusion, the court considers that the current Finnish system as a whole has not been shown to be disproportionate in its effect on the applicant, and that a fair balance has been struck between the competing interests in the present case. Accordingly, there has been no violation of Article 8. So the applicant lost the case. In this case, Helen Keller and two other judges issued a joint dissenting opinion where they stated that they disagreed in the majority's finding that there had been no violation of Article 8. They also said that the case should have been dealt with differently with regard to both Article 12 on marriage and Article 14 on non-discrimination in conjunction with Article 8. So there we have this question which arises between the effective protection of human rights on the one hand and ensuring a certain self-determination by states on the other hand. So my first question is then, why did you dissent?
Let me start by saying I probably learned most when I was doing research for this dissent in my whole 3 years. It's amazing. I didn't know that in the Middle Age, in clerical circles, a third gender was accepted over many, many years, if not centuries. I didn't know that in India there was a third gender until the colonial time of the Brits. So I got aware that the distinction that all human beings must be either female or male is probably a rather new idea in the history of mankind. This just as an introductory remark. In my view, Hämäläinen raises two very fundamental issues. On the Article 8, the dissenters raised the question, is there a limit to the doctrine of margin of appreciation? I think we all agree there are certain areas in which we have no European consensus. Medical procreation. We have a development in the scientific world, different cultural or religious understanding what is possible, what should be possible. And there the court says, okay, let's develop in Ireland and Italy something different might be the standard than in Denmark or Poland. That's fine. We all agree on that. But Hämäläinen raised another question, namely, is there a limit to the margin of appreciation if it comes to an aspect which is closely linked to your personality, like gender, like sexual orientation, like skin color, like age? I don't say that any differentiation between or among those criteria are per se incompatible with the convention. But if a legal framework ties certain consequences on these issues that are linked so much to your person, to your personality, we have to be very careful. Why? You cannot change those aspects of your personality so easy. So our argument was, we have to be careful, and if we balance what is at stake in Hämäläinen, then we came to another conclusion. So the fundamental first issue was, are there limits to the margin of appreciation if it comes so close, I would say, to your internal fora, to what is so intrinsically linked to your person? Now, the second fundamental issue is discrimination. Article 14, in particular in conjunction with Article 8, has become a very powerful tool of the courts. In many instances, the court could just, via Article 14, go into a sphere and say, here we have a discrimination issue. However, with Article 14, we have a problem. There is a pitfall. And the pitfall is, what is the comparable group? What is the tertium comparationis in more philosophical term? Let's go back to Hämäläinen. We have a couple. They were married over years. They have a daughter. Now one person transitioned from one gender to the other. The couple still want to be a married couple. They never claim to be homosexuals. Can now the state come and say, legally we treat them like a homosexual couple? Or is it rather that the state failed to find an adequate solution for this particular situation? We, the dissenter, were convinced of the first. It is, in our view, just too simple to say they are equal as a homosexual partner. And once again, it is not something, you know, if you wear black socks or brown socks, it comes very close to your personality. Mr. Heimelainen or Mrs. Heimelainen was traveling a lot, so this person is affected whether you can see in her identity documents whether she is male or female, and it doesn't correspond. So it comes very close to your personality, to what you're doing in your daily life, in your private life, in your intimate sphere. And once again, if we do the balancing, the Finnish government argue we have to protect the traditional understanding of marriage. Okay, I accept that. I think traditional marriage between a man and a woman, this is a value. We should protect that. But is it justified not to amend the identity card of this applicant? Is this really at stake? Isn't it that the couple lives as it did for many years? And is it really a threat to the traditional understanding of marriage? This is my view of Heimelainen.
If I should challenge you, and you say that there are different values, of course this is very important to the person concerned. But you also refer to traditional values about that marriage is for different sexes. But one thing is to balance these different values. Another question is who is to decide about this balancing? Is it the International Court in Strasbourg, or is it the local community, in this case Finland, and applying a principle of subsidiarity that the question should be resolved at the level which is closest to the case? Why shouldn't the public democratic channel in Finland be decisive?
Well, here I would say, of course, it is first and foremost for the national legislator and the national authorities to decide the case. And if they have done so, okay. Our task, the court's task, comes into play if all the security net on the national level failed. And in my view, it failed in Heimelainen. It would have been so simple just to have a practice that in those few cases where one person in a traditional marriage has transitioned to the other sex, that you just allow it to continue their marriage, and you just on a case-by-case practice change the identity numbers. No big deal. So, in my view, of course, it is for the national authorities to deal with those questions. But if the security net has not provided enough human rights protection, then it is very much up to the court to ensure it.
And does it make a difference for you, this concept of a European consensus? We know that the legislation in different countries in this area varies a lot. Would you say that you have a responsibility to protect this person without respect to an European consensus or an emergent consensus or whatever?
I think in general the court deals with European consensus in a very, I would say, rational way. There are several areas I mentioned before, medical procreation, where I really think we have to wait and see how quick the development in science, but also in society, will go. But there are other areas where it is dangerous to wait until you have a large European consensus, because it might be a way of discriminating persons who have suffered so long. So sometimes, once again, if it comes very close to your personality, I think sometimes there the court has to push.
Another question also related to this is the development both in the last ministerial conference and it's a declaration pointing out subsidiarity. We have the new Protocol 15 also referring to subsidiarity and the margin of appreciation. Should the court take account of this, or just continue its practice as before?
Well, subsidiarity will be part of the preamble of the convention once the new protocol comes into place. And in the preamble, that means you all know that it is not part of the hard law, but we should interpret the whole convention in the light of the subsidiarity. And I hope very much that the court will continue its practice. I mean, in particular in areas where we have an established case law, it would be impossible to turn that around simply on the grounds of subsidiarity. I mean, what is torture? What is inhuman and degrading treatment? We cannot go back and forget the last 30 years and say, now we have subsidiarity, let's allow a little bit tougher interrogative measures than before. That, I mean, the court would not be credible anymore.
Thank you. Let's move to a different case. That is the El Masri versus the former Yugoslav Republic of Macedonia from 2012. This case concerns the so-called war on terror. It concerns the claimed black sites in Europe where people were detained. They were transported between different parts of the world in secret, and some of them ended up at Guantanamo. This case concerned a German that was detained in Macedonia. He claimed that he was tortured there, that he was brought to probably Afghanistan. He could not prove where he had been brought, but he was eventually released, and therefore it was possible for him to go to the European Court of Human Rights after exhausting local remedies. And the court concluded that he had been subject to inhuman and degrading treatment as well as torture, and that Macedonia had also violated Article 3 by transferring him to the custody of U.S. authorities. And we have a more recent case from this year, case of al-Nashiri versus Poland, which also concerned these black sites. This case raises very many different issues, but if we come back to one issue that we discussed earlier, the right to truth. In this case, Helen Keller and three other judges expressed a joint concurring opinion. And there they said that the applicant was denied the right to truth. And I think you said earlier that a right to truth follows from Article 2 and 3, the procedural aspects of them. But there are some dilemmas one thing is the legal basis for a right to truth. It's not stated explicitly in the convention, but also the possibilities of finding the truth. In this case, and also in the later Al-Nashiri case, the government did not provide all the information that they were requested. So how can you establish the truth when you don't have access to all the information? And we have also the question of burdens of proof, that the court applies certain burdens of proof, and how is it then possible to establish the truth, whatever that is?
Allow me to say, Masri was a great case. It's one of the cases which make me feel it was the right decision to leave my job at the faculty to go to Strasbourg for 9 years. It was a judgment that went around the world. It's a judgment that shows that, of course, it is a judgment formally against Macedonia, but it is a judgment that deals with CIA. It's a judgment that goes treats very much the United States, and it shows that even such powerful states like the US cannot escape completely global justice. And you sit in the case and think, wow. Now, the question that you have raised, the right to the truth. There is a big difference between El Masri on the one hand and Al-Nashiri versus Poland, the most recent. In El Masri, we had abundant evidence. El Masri was so clever to go to a doctor right when he was relieved. He had still his hair, and he went twice on a longer hunger strike. So they could, on the basis of an analysis of his hair, say that he had spent several months in an Asian country and that he was several days in this month under food restriction. We had just several pieces of a large puzzle where we just said, well, we see the picture of that puzzle very clearly. He was abducted, he was tortured, he was brought back and then just put on the street. We could all see that. It was much more difficult in Al-Nashiri. Read the judgment. It's 200 pages. I started to read. I couldn't stop. It is like a criminal story. You go on and you think, oh no, oh no. And it's just fascinating. I was not in the Polish case. I only was in El Masri. And the right to the truth, we had the Fava report, we had the Marty report, we had all those data from the logbooks, we had his analysis from his hair. He could write a sketch from the Abu Ghraib prison. I mean, how could you say we could not establish the truth? We had overwhelming proof that everything was correct what he described. We very much were convinced by that.
So it's a case-to-case assessment whether you have enough information to really establish what has happened.
Sure.
Yeah. Okay. The final judgment is called Catan and others versus Moldova and Russia. And it concerns the area of Moldova, Transnistria, which is then not under the control of Moldova as a state, but is under what the court said, effective control of Russia. We can draw the comparisons with Ukraine today, I think. The question was then that children with a Moldovan language were not allowed to use the Latin alphabet in the schools. And they claimed that that was a violation of Article 2 of Protocol 1, the right to education. And the court said that Moldova had done everything that it could, but it didn't control the territory, whereas Russia, on the other hand, was responsible for not for the detailed control of the school, but for the overall, the effective control of this separatist area of Moldova. So the result was that Russia was found to violate the right of education of Article 2 of Protocol 1. In this case, Helen Keller and 5 other judges expressed a jointly partly dissenting opinion, not about the right to education, but claiming that the court should also consider the Article 8 on privacy, right to privacy, and Article 14 on non-discrimination. First, again, why dissenting in this case?
From all those cases that we now have discussed, this is probably the most difficult one and the most particular one. Transnistria is one of those regions in Europe where you have a discrepancy between state borders and the control inside the region, like, for example, in Abkhazia, South Ossetia, Crimea, the eastern part of Ukraine, where it gets really difficult to say, on the one hand, we have an individual applicant, and on the other hand, normally we have a state authority. But who is the state authority if you have no state authority, let's say, as it would appear according to the national boundaries? So this is one difficulty in Catan versus Moldova and Russia. Then the case raised issue under the first protocol, right to education. The Transnistrian authorities forced the population to use a kind of artificial language. It is Romanian, but written in Cyrillics. It's a language that does not exist in the whole world. And the court concentrated on the right to education and just said there is no separate issue under Article 8. And there comes the dissent. you have to be aware, the children had to go from one part of the country to the other. They had to make border controls. The children came home with a book in Cyrillic. They had to learn that, whereas the parents write the language in the Roman alphabet. Teachers who did not want to teach this artificial language, they lost their jobs. And here we said, how can the court say that this does not affect family life? If your children come home and they write in a different alphabet than you do, don't you think that at a certain moment your family life is affected? If you're a teacher at the school, you don't want to write, and you lose your job, you don't think that this will affect your family situation? So it was obvious for us that the court did not want to go into the Article 8 issue because this is a hot potato. Belgian language cases, it goes back very to the beginning of the court's case law. Language and family life, it's a hot potato. So it was an easy solution to say no separate issue on the Article 8.
But in this kind of situation where a state is not controlled over its territory, and there is a neighboring state, in this case Russia, who is controlling the area, we have both the possibility of individual complaints, like in this case, but there may also be interstate cases as between Georgia and Russia. Can you say something about what could and should be the role of the court in such very difficult political situations?
Well, the interstate proceedings are completely different than the individual applications. Normally, if individuals come to Strasbourg, it is a kind of a simple case in the sense that you have the small individual and the big powerful state. And this is the understanding how the court will deal with the matter. Now, in interstate case, you have two powerful governments, and they fight against each other. And this challenges the internal functioning, the atmosphere in the court dramatically. And in those interstate cases, fact-finding is very often the biggest problem that we have. So it's not, in an individual case, it is very often, it is easy. The individual makes a prima facie case, and then the burden of proof shifts to the government. And the court's case law is very clear. The government is the only organization who can provide the information and should provide. And if not, it is a violation. But in an interstate case, the first government will claim, they will put forward witness, they will put forward evidence, and then the other government come and they will challenge it. And very often this is, from a practical point of view, a huge problem for the court. We're not equipped. Theoretically, we can go for fact-finding, but would you go in an area where it is a war situation or a civil war situation? Are we equipped to gather those proofs, those evidence? I doubt.
I think we could continue with these different cases for a long time, but I would like also to end up with thinking about the future of the court. And most of us will know that the court has been facing the difficulties of what has been called its own success, the number of cases. now the court has been able to reduce the backload, so that's a positive development. But one can then ask, well, is the danger of collapse over? But there is also this other issue. If we say that the first is the backlog issue, the second is the backlash issue, where there has been critical comments about the court. We have the UK presently with difficulties concerning this case on giving prisoners voting rights, and they are discussing the future of the convention of the court in relation to the UK. And there are also critical sentiments in other countries. So can the court survive both the backlog and the backlash?
I think in coping with the tremendous amounts of pending applications, the court did a pretty good job. We have reduced the so-called Brighton backlog for many countries, and for many countries, not for all, in particular not for the big countries like Russia, Ukraine, Turkey and Italy, but for many countries we have achieved what we call one in, one out, so that for each case that arrives in Strasbourg we are able to get rid of one case in a sense that it is declared inadmissible, or we really deal with the merits. So I think for the rest, it is really up to the member states of the Council of Europe to do their job. We have so many countries with systemic failures. Italy, for example, they have still a systemic problem with the judiciary. They have a systemic problem, we just saw it this morning, in environmental issues. They have a systemic problem with overcrowded prisons. I mean, it's not just Russia or Ukraine, it's Italy, a founding member of the EU. I really think that those member states should do their job and improve the human rights situation on the ground.
But we can conclude on a positive note, or?
Well, I hope so. As a human rights lawyer, you always have to be positive, because otherwise you would not do the job.
Okay, I think we close the formal interview here, and I would like to express my sincere thanks to Judge Helen Keller. I think this has been very interesting, and thanks a lot.